Hi, everyone. We talked in the last video about some federalism questions. Um, I want to talk now about separation of powers for a minute in the context of executive power. Um, Before we revisit federalism, the big federalism issue, which is dormant commerce. Now, it's entirely possible in a fact pattern involving federal constitutional law that you'd be asked about presidential authority. So keep in mind, first of all, that as a general matter, the authority of the President of the United States is governed by Article 2 of the Constitution and the Youngstown case, the famous Youngstown case, and in particular, Justice Jackson concurring. So if you see, let's talk for a minute, I jumped ahead of myself here, about what kind of facts would trigger a conversation about executive authority in some context. The most likely would be that you see an executive order signed by the president and issued to a federal agency of some kind. The presidents, however, don't always set policy through executive order. Sometimes they issue memorandums. They have reasons for doing that. There's fewer legal requirements for issuing a memorandum. A memorandum you might regard as an executive order light, but that also could trigger a discussion of executive authority. You also may see an issue where the president has fired somebody, and the question is under what circumstances does the president have the authority to fire somebody? You also want to look out for fact patterns where the president is saying, you can't sue me while I'm in office. There's a more recent case where the President Trump claimed that he couldn't even be investigated in a criminal case, let alone charged while in office, and the court resolved that case not in favor of the president. But that's so recent, I doubt it'll be on the October Florida bar. One never knows, but I wouldn't necessarily expect that. I would expect a fact pattern, if at all, about this issue where the president's claiming I can't be sued while I'm still in office. You might also see a fact pattern where the president or the vice president or somebody else around the president in the White House or the executive branch is claiming that they want to hold secret some kind of conversation or information involving the president or vice president. So you could see a claim of privilege. And finally, we're going to talk about in this short video is vetoes. If you see a fact pattern where the president vetoes a bill or sits on it, we'll have to discuss very briefly how you would handle that issue. So back to the big point. If you see an executive order, a memorandum, some policy initiative by the president, and there's a general challenge to the president's authority, you would apply Youngstown Justice Jackson. That's a pretty simple analysis. If either the Constitution or a statute enacted by Congress authorizes, either explicitly or implicitly, the president to do something, then the president's in quote-unquote zone 1, where his or her power is at its maximum. If, on the other hand, there's disapproval, as for example, when Congress would debate a proposal by the president and vote it down, that's pretty strong evidence that Congress disapproves or does not want the president to do X, then the president would be in zone 3, where the president's power is at its minimum. Then you have zone 2, which Justice Jackson referred to as a zone of twilight. I would use that terminology on a bar exam if this comes up. Zone 2, courts will look to a couple things. Number one is whether it's foreign policy or domestic policy. The president gets more leeway with foreign policy than domestic, right? And then we're deciding, can the president do something when the Constitution and statutes seem to be silent about it? So again, when that's the case, when there doesn't seem to be any indication of whether the president has authority in the Constitution or statute, courts look first to whether it's foreign policy or domestic. The second thing you want to look at is the history, right? Is there anything in the fact pattern about whether the other branches, the legislative and judicial branches, have acquiesced for years or decades, when the president did whatever this president was alleged to have done. So that's how you do an overall Youngstown analysis. If there's a question about executive authority on a bar exam, and you do not cite Youngstown and go through the zones, I don't see how you get credit for that answer. Maybe you get some credit for saying Article 2, but that's about where it would end. Now, there are sub-issues under executive authority that you have to watch out for. I mentioned the president firing somebody, and this is handled under the appointments clause, right? The president appoints and the Senate confirms officers of the United States. When the way this is usually tested would be what the president removes somebody. If the person the president removes is a purely executive officer of the United States, think Secretary of State or any other cabinet secretary, undersecretaries, agency heads like the head of the FBI, the head of the EPA, people like that who work exclusively in the executive branch. And by the way, recently the Supreme Court held that the same rules apply to the person who runs the Consumer Financial Protection Agency as an executive agency. So when the president fires one of those people, the president may do that at will. The court has said, although the Senate is necessary to confirm an officer of the United States, the Senate does not have to concur in the president's decision to remove one of those people. So again, if it's a purely executive officer of the United States, that person can be removed at will by the president. On the other hand, there are certain independent, normally we would call this a commission or some kind of entity that Congress creates that's supposed to be independent, at least exercise some independence from the executive branch. These are called quasi-legislative or quasi-judicial officers. In that case, Congress can require cause, but Congress cannot be overly explicit in determining what constitutes cause, because courts have said that that is an executive decision, an executive function, kind of a quintessential type of executive function to decide who should be removed and why. So next sub-issue would be what I mentioned earlier, the president saying you can't sue me while I'm in office. The rule is that the president is absolutely immune from civil liability for anything the president does that is even arguably within the scope of the president being president. And that includes being a politician and a partisan. The president, however, under Clinton versus Jones, is not immune from liability when the president does something. Well, you want to look at the time frame, first of all. If it's before the president was president, that obviously cuts against the president claiming immunity. But furthermore, anything the president does that's wholly and completely outside the scope of the president's role and duties under Clinton versus Jones, when that's the case, the president can be sued for that and can be sued while in office. So that's the rule with regard to, or those are the rules with regard to immunity. Privilege, first of all, should be invoked by the president or the vice president. Typically, it's a much stronger case for privilege when you see some kind of national security discussion going on or policy making. The more you depart from national security or policy making, the less likely privilege is to prevail. Also keep in mind the Nixon and Cheney cases. In the Nixon case, the court said on a criminal matter where somebody's life or liberty is at stake, the need for the information outweighs the need to keep the information secret. So you have this sort of balancing test going on, balancing the need to keep the information confidential and secret on the one hand, right? How important is it? Does it involve national security? Does it involve sensitive policy matters? Does it involve situations where there has to be frank discussions between the president and somebody else or the vice president? So you weigh that against the need for the information. So in the Cheney case, where there was a civil case where not a whole lot was at stake, the court said the privilege does not give way. The need for confidentiality outweighs the need for disclosure. Finally, keep in mind the veto rules. Vetoes operate one way. The president gets to veto an act of Congress, not the other way around. There's no such thing as a legislative veto. The president's choice is to sign the bill in its entirety. Remember, Clinton versus New York, there's no such thing as a line item veto. So the president either signs the entire bill, vetoes the entire bill, or just sits on it until Congress's session expires. If the president simply sits on a bill, that's called a pocket veto and has the same effect as a veto. One more thing about vetoes, a veto can be overridden by 2/3 vote in both houses of Congress. So those are the rules in a nutshell. Keep in mind as we go through these videos, as I keep saying, I'm painting with a broad brush. We're trying to make sure here you don't miss top level issues. And so when you see something involving the president in a federal common law question, know Youngstown, know the appointments clause, know the rules about immunity and privilege, and have a general sense of how vetoes work. That should at least get you, right, some credit for an answer about executive power. Now, keep in mind that there are templates accompanying each of those videos. It's one document, but there are templates for each of the issues we just discussed in the description box below. Hope that helps, and we'll be back later to talk about dormant commerce.